last year, allegations against former Ninth Circuit Judge Alex Kozinski surfaced when the Washington Post published an article detailing disturbing allegations of misconduct by the judge. You clerked for Judge Kozinski for 1 year in 1991, 1992. Some of your opponents have suggested that you must have known about these allegations. This seems to me to be an effort at guilt by association, which is not the way this committee should operate in any way. With that in mind, I want to give you a chance to answer a few questions about Judge Kozinski so that we're all operating on the same foundation of facts. First, how long have you known Judge Kozinski?
I clerked for him in 1991-92, so I started the clerkship 27 years ago.
Second, I understand from media reports that Judge Kozinski operated an email list where he would send inappropriate material. Were you on this email list?
I don't remember anything like that, Senator.
How often did you talk with Judge Kozinski on the phone?
Not often. Not often, Senator.
How often did you see him in person?
Again, not often. Maybe when there was a legal convention or...
That's what a lot of people don't seem to understand, you know.
I was not working in the courthouse. He was in the Pasadena courthouse in California with small courthouse with 10 other Court of Appeals judges in that courthouse. I, of course, was working in Washington, D.C.
When you did see and talk with Judge Kozinski, what type of things did you talk about?
We were among the 12 co-authors of the Brian Garner-led book on judicial precedent. So for several years, that was a project all of us were, the 12 of us, I guess it was in total, were working on that. Diane Wood, Chief Judge of the Seventh Circuit, and,
right.
And Justice Gorsuch was also a co-author, so we worked on that as a group. And then Justice Kennedy, for the last 30 years, had Judge Kozinski run Justice Kennedy's law clerk hiring process, and in the course of that process, I would have communications with the judge.
Okay. Did you know anything about these allegations?
Nothing.
Okay. Before they became public last year?
No. When they became public, you know, the first thought I had was no woman should be subjected to sexual harassment in the workplace, ever, including in the judiciary, especially in the judiciary. And when I heard, when they became public, I think it was in December, it was a gut punch. It was a gut punch for me.
It was for me, too.
It was a gut punch for the judiciary. And I was shocked and disappointed, angry, swirl of emotions. No woman should be subjected to sexual harassment in the workplace. And I applaud Chief Justice Roberts' appointed committee of judges to establish better procedures. Chief Judge Garland did the same thing for our court. And those are first steps. I don't think they're final steps by any stretch. And this is part of a much larger national problem of abuse and harassment. And one of the things we've learned is we need better reporting mechanisms. Women, in particular in the workplace, need to know if they're the victim of harassment, where to report it immediately, who to report it to. They need to be know that they'll be safe if they report it. They need to have a safe working environment and be safe if they report it. They won't be retaliated against, and they'll be protected if they report it. And that's part of the steps, or one of the steps that's, I think, being improved as a result of the working group or committee that the Chief Justice has appointed. And I'm interested in doing everything I can to assist those efforts to make those workplaces safe. Again, it's part of a broader national problem, whether it's priests or teachers or coaches or doctors or business people or news people. There's a broad national problem, that needs to be addressed, including in the judiciary, and
Okay.
I applaud Chief Justice Roberts for doing so.
Okay, I'd like to talk to you now about the Chevron doctrine. Now, this is an important judicial doctrine that takes its name from the Supreme Court case that created it back in the 1980s. In that case, the Supreme Court instructed federal courts to defer an agency's interpretation of the law if the law is, quote, ambiguous, unquote. Some of your academic writings express skepticism about the Chevron doctrine and concern that it allows an administration to impose its policy preference by avoiding the political process. I can understand why this would be appealing to an administration, but I also think it's a threat to the separation of powers because it transfers power from Congress and the judiciary to the executive branch. That's why I've introduced the Separation of Powers Restoration Act to reverse the Chevron doctrine. Many members of this committee have co-sponsored this legislation. And as someone who has written extensively about the separation of powers, can you tell us why the separation of powers is so important and how it helps to protect individual freedom?
The separation of powers protects individual liberty because it responds to the concern the framers had, that something Senator Klobuchar said yesterday from Federalist 47, that the accumulation of all power in one body would be the very definition of tyranny. So Federalist 47 talks about that, Federalist 69. So the separation of powers, to begin with, protects individual liberty. It does so because Congress can pass the laws, but you can't enforce the laws. A separate body has to decide to enforce the laws. And then even if the law is enforced, and a citizen may say, well, I want someone who didn't pass the law or enforce it to decide whether I violated the law or whether the law is constitutional. And that's why we have an independent judiciary to guarantee, as an independent matter, our rights and liberties. And the three branches, therefore, do separate things because it all tilts toward liberty. It's hard to pass a law, as you know, in the Congress. And then, even if it does get passed and affects your liberty, a separate body has to decide, usually U.S. Attorney's Office, to enforce the law, and that's a separate decision. That helps protect your liberty. And then even if that happens, you go to a court and you say, either I didn't violate that law, as I'm accused of doing, or that law is unconstitutional, or they're interpreting that law in a way that's not consistent with what the law said. The court independently decides that. It's not the members of Congress or the executive deciding that. That's how the Constitution's separation of powers tilts toward liberty in all its respects. Now, as to your specific question, Senator, one of the things I've seen in my experience in the executive branch and in the judicial branch is a natural tendency, but it's a natural tendency that judges need to be aware of and then respond to. So here's the natural tendency. Congress passes laws, but then can't update the law. So maybe it's an environmental law, or maybe it's some kind of law dealing with national security. Let's take those two examples to illustrate. And then an executive branch agency wants to do some new policy and proposes a new policy to Congress, but Congress doesn't pass the new policy. What often happens, or too often I've seen, is that the executive branch then relies on the old law as a source of authority to do this new thing. And they try to say, well, the old law is ambiguous, so we can fit this new policy into the old law as justification for doing this new thing. And I've seen this in national security cases. I've seen it in environmental cases. You see it all over the place. It's a natural phenomenon because the executive branch wants to implement what it thinks is good policy. Now, when those cases come to court, it's our job to figure out whether the executive branch has acted within the authority given to it by Congress. Have you given them the authority? And my administrative law jurisprudence is rooted in respect for Congress. Have you passed the law to give the authority? I've heard it said that I'm a skeptic of regulation. I am not a skeptic of regulation at all. I am a skeptic of unauthorized regulation. of illegal regulation, of regulation that's outside the bounds of what the laws passed by Congress have said. And